Hey everybody, this is attorney Andy Marcantel from the Attorneys on Retainer program. You know, a few months ago, we sent the USCCA a letter with a lot of questions. We wanted to know about their program, certain language in their fee agreement that we didn't quite understand, as well as questions about some recent high-profile cases involving the USCCA. The questions just weren't generated by us. You guys helped us make this letter. There were some great suggestions for questions for the USCCA that we included in our letter. This was all done in the spirit of trying to get transparency to the marketplace about the differences between different self-defense programs. Well, unfortunately, we never heard back on our letter from the USCCA, but we wanted to share that letter with you guys today and talk about it and why we think these questions were so important. But there's some breaking news. In fact, the USCCA sent around a notice to all of their members announcing that they're adding some new features and updating some of the language in their contracts with their members. Now, for those of you who are paying attention, a lot of this language and these new features they're adding sound suspiciously like the features and the language that the Attorneys on Retainer program has been offering in our program since the very beginning. This doesn't surprise us. We knew, given the very, very public critique of their program and problems that they've been receiving surrounding this problematic language, that they were due for a change. But here's the issue. The changes they've made do not address, by a long shot, many of the problems that we have pointed out with their program. So I want to let you guys know we've got a full critique of their new policy coming out very soon. And just like every single one of our other review videos for self-defense policies, we plan to give it a full, fair, and balanced review. We're going to compliment the USCCA on certain changes that they've made that we think are a net positive, while also pointing out the issues that still remain and the problems, some of which are pretty significant in our view, that these policy updates do not address. So stay tuned for that new review video. But for today, enjoy the video. Attorneys on Retainer sends a certified letter to the USCCA with a whole bunch of important questions that you guys have been asking. How did they respond? Stay tuned to find out. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners at the Attorneys for Freedom Law Firm here today to talk about a letter of inquiry that we sent to the folks over at the USCCA. How you doing today, Marc?
Good, man. I'm just excited to kind of close the chapter on all of this USCCA, Kayla, Giles, Alan Colie type stuff. Because, we've had this issue hanging out there. We told people quite a few months ago that there were still questions people were wanting to know. We were wanting to know. USCCA had put out a video a long time ago saying there was inaccurate information put out to the market. Okay, let's do our best to straighten it out. So we sent a letter. People will remember, who have been following us for a while, they will remember. We sent a letter to Tim Schmidt.
We sent this a long time ago,
we sure
too.
did.
February 8th, 2024.
And they've had quite a bit of time to respond, and doesn't seem like there's going to be any activity on our letter.
Yeah, spoiler alert. Because I think the tag that I just did for this episode was, how did they respond? Sorry, guys. They didn't respond.
Crickets. No response.
But we think it's worth it to go through this letter anyway, because there are some really important questions that we've kind of collected here. And also, we haven't given up hope that they might respond, or that perhaps this video will be shared with the folks over there, and maybe they'll reach out and address some of these questions.
Look, we're in charge of what we do, right? We're not in charge of what USCCA or what any other company does. We take full responsibility for how we act and what we do. And so we acted appropriately. We asked questions. We sent a letter. And if they chose not to respond, that's on them. We offered to do exactly the same, reciprocal, answer some questions for them. I think the goal here is to get information out to the market, to let people decide for themselves. Some people want both companies. Some want neither company. That's fine. Our purpose here is not to disparage any company. There's a big market out there. USCCA does some things we don't do. And so we acted in a professional way. And so let's just get into it. Let's let people decide for themselves.
Yeah, just a couple of things before we hop in. I think it's important to note just how our brains are wired, just from being lawyers, perhaps. This is the type of thing that we do. Whenever there's a party that we have some questions for, maybe something that's relevant that we want to show some information, maybe for a case, maybe for a client, maybe for the general public, in cases of public interest, we try to approach it civilly. We'll call up the attorney for the other side. We'll send them a detailed letter. And in situations like this where there's a lot of questions, we don't want to snipe anybody or surprise them or do a gotcha moment on the phone. We want them to take their time and respond to these things. That's why we allowed months to pass before making a video about this. But that's just kind of how we operate as lawyers on a day-to-day.
I mean, I think that's how we should operate as humans, right? Get the facts, ask questions. So maybe just a little setting of the stage. I think for some, let's assume not everybody is following this stuff, but I think it was our client or somebody out in YouTube universe brought to our attention, hey guys, there's this Kayla Giles case out there. We looked into it. We didn't know what had happened at the time. We started asking questions in our videos. What happened? Obviously, she was a USCCA member. She was charged with a very serious crime initially, first-degree murder. Then that was dismissed and second-degree murder was brought. And she was given an attorney by USCCA. USCCA paid $50,000 for that attorney. Again, we were endeavoring to find out what happened. We called that lawyer. We said, hey, man, what happened? He said, yep, USCCA paid me $50,000 to represent Kayla Giles. I thought it was a defensible self-defense case. And then they pulled out the rug from under me and said, we're not funding it anymore, and that's all I know. I don't know why. He said that there were statements made by the daughter. We talked about that in our video. In fact, we should put a link to some of these videos if people are interested. He said, I was trying to get their attention, say, hey, there's these great statements made by my client's daughter, Kayla's daughter, that are very relevant to a self-defense claim. Don't you want to see these before you make a final decision here? And he explained to us the answer was no. So we've been trying to explore that situation. People know if they've been following us. We actually spoke to Kayla and we brought an expert in, a use of force expert in, who's reviewed the entire case, and we dissected that. We'll put a video down below if you're interested. So this letter was an effort to follow up on some of that. Say, what happened? Then there was the Alan Colie matter. Same thing. It was brought to us. People said, hey, there's this guy, Alan Colie. The news reported that there was an issue with USCCA. The prosecutor had moved for a subpoena to try to get information from USCCA in prosecuting Alan Colie, who was a USCCA member, and it appeared, he had a public defender. So we were asking questions. Why didn't USCCA cover Alan Colie? I'm still confused about that. He had a public defender. He went to trial. He was acquitted on one charge, convicted on another. And Tim Schmidt came out with a video and said, yep, we're going to cover the appeal. USCCA is going to pay for an attorney to do the appeal for Alan Colie. And he selected a public defender. Then there was this email allegedly from Alan Colie. I'm trying to say this with a straight face, signed USCCA member, sent to Tim Schmidt, and a lot of people thought that was very strange. So we couldn't get answers. We didn't know. There were allegations. There was false information, misinformation. So we endeavored to clear the record. Tell us what happened. That's what this letter was about.
Yeah, both of these cases had a lot of things just on their face that were very, very questionable. And we became interested in these cases because they were so hotly contested by the gun community. There was so much debate on both sides of these things. The very first thing that got me interested in the Kayla Giles case, for instance, is that I saw that a lot of people were saying this is an obvious case of premeditated first-degree murder. And in fact, Mr. Schmidt himself made a video where he was saying this is a clear-cut case. It is just absolutely clear that a member committed premeditated first-degree murder. And then all I had to do to question that was simply look at the amended charges. The prosecutor dismissed the first-degree murder with premeditation, and the reason given by the prosecutor was no likelihood of conviction, no reasonable likelihood of conviction. So the prosecutor didn't even agree with that assessment. Then we do what we do as lawyers when we have questions. We called up the other party. We got on the phone with the lawyer of Kayla Giles, who was originally hired by the USCCA. And as it turns out, that's exactly what we did in Alan Colie's case. We had lots of questions about that case, too. And as I mentioned, as lawyers, our brains are hardwired not to, kind of speculate and look aimlessly at something, but actually to try to get to the root of things. And so we got on the phone with Alan Colie's lawyer, who was his lawyer at the time. We've spoken to him a number of times. Both really good attorneys, as far as I can tell. Both willing to talk pretty openly about certain aspects of the case. I think they were both very ethical and professional with what they kept in terms of client confidentialities. But we started asking questions, and frankly, it's generated a lot more questions. I'm not satisfied that my questions have been answered properly.
Yeah, so let's let people decide for themselves. The letter speaks for itself, and so people will either view this letter and say, you guys did the right thing or you guys did the wrong thing, but we did what I think anybody would do, trying to get information about these cases. We wrote a letter and asked them straightforward questions.
Yeah, and another source of questions in this, not just our own inquiries, but on several videos that we did where they're asking questions down in the comments. And we even started to solicit questions at some point a few months back. We're like, hey, we're planning on sending them a letter. If you want a question included, throw it in the comments. And so a lot of these questions in here that we asked were inspired by those of our viewers and our AOR clients. So thank you for that. And so here is the letter that we put together. It's dated February 8th, 2024, and at the top you can see that it was sent via certified U.S. mail and email. So that's where we confirmed receipt to USCCA and Delta Defense LLC. Attention line is to Mr. Tim Schmidt. He's the CEO and co-founder of the USCCA, and it is regarding YouTube videos. So here's the body of the letter. Dear Mr. Schmidt, please be advised that I am the owner of the Attorneys for Freedom law firm, which owns and administers the Attorneys on Retainer program, or AOR. As you know, our respective companies have exchanged various YouTube videos about each other's programs. In your recent video entitled, They Are Lying to You, dated December 22nd, 2023, you assert that USCCA has been subjected to unjust criticism, false accusations, and fraud. You also identified lying and intellectual dishonesty as tactics you oppose. While I am unaware of exactly what advertisements you are referring to, nor did you implicate AOR in any way, I absolutely join you in opposing such advertising or promotional tactics. I can assure you that neither AOR nor my law firm will ever engage in such tactics. Further, I join you in your love of competition and the free market. Indeed, as a pro-freedom organization, my law firm has an almost 3-decade history of advocating for all individual rights and honest free market competition. It appears we stand together on these points. I applaud you for your efforts in these areas. I am committed to distributing fair and accurate information about alternatives to AOR. I recognize and have stated on several occasions that the USCCA offers certain products, including vast training resources and liability insurance against civil judgments, that AOR does not offer. Indeed, I have previously recorded and distributed a video critiquing AOR on these points, as well as a video exceeding an hour in length, reviewing every word of the AOR written agreement. My organization is entirely transparent about AOR and its alternatives. In an effort to gather accurate information about the USCCA and its offerings, I am writing to you in the hopes you will answer some specific questions about the USCCA's insurance coverages, as well as some recent high-profile matters which generated substantial controversy about the USCCA. While there are several questions, all of them can be answered with short answers, and in many cases with either a yes or a no. However, please feel free to offer a more detailed answer if appropriate. I recognize you are not obligated to answer any questions I pose. However, I am hopeful you will respond timely to my questions so we will have accurate information with which to compare and contrast our respective programs. Additionally, in the same spirit of cooperation and full disclosure, I am willing to respond to questions you desire to ask about AOR, that do not violate attorney-client privilege or our ethical duty of confidentiality. Moreover, I am willing to engage in a friendly and productive discussion comparing and contrasting our respective programs with either you, Attorney Tom Grieve, or another representative of the USCCA or its insurance company in either a live or recorded format. Please let me know if this offer is of interest to you. I expect any discussion will be open, honest, respectful, civil, and productive. That said, my questions are as follows. And then we list a number of questions.
All right, so let's start with question number 1. On page 2 of the USCCA's insurance policy, under Section 2, entitled, quote, Exclusions, subsection B states, criminal acts are excluded. I am requesting clarification about this exclusion. A. Who decides whether a charged crime constitutes a criminal act? B. What criteria is used to decide? C. At what point in a criminal case is this determination made? D. Is the determination subject to further review as the case proceeds? E. Is any assigned attorney obligated to provide any discovery to the decision maker at either the USCCA or its insurance company? F. What happens if an assigned attorney refuses to provide any discovery or discuss the case with the USCCA or its insurance company? All right, so that's question 1. I mean, I think that's pretty straightforward. It seems like a pretty fair question. That's one of the big differences between our program and USCCA. They exclude criminal acts. We don't exclude criminal acts.
Yeah, we hit so many importance in there, but the big question of who decides is so important, right? But at the end of the day, with the Attorneys on Retainer program, it's our law firm that makes the decision at the end of the day. An insurance company or a bean counter or somebody who's interested in possibly disclaiming liability, they're not the person that makes the decision. And so I think the who decides is a huge, huge question.
Yeah, and to be fair, the question's different, right? They're deciding whether or not it's a criminal act.
Right.
That's not what we're deciding. If it's a criminal act, that's not a problem for us. What we're deciding is whether somebody in good faith tried to act in self-defense, even if they blew it and it's a criminal act. So it's a different question entirely, but I think a lot of people are concerned about this exclusion for criminal acts with USCCA. This would have been a great opportunity for USCCA or Tim Schmidt or Tom Grieve or somebody to say, here's the answer to these questions. But again, no response.
So that's the who. The when is implicated here too several times. The when is super important. Mm-hmm. When is it made? Is it right at the beginning when it's charged while the person is still presumed innocent under the law? Or is it reassessed? And you ask about that. And of course, this reminds me of the Kayla Giles case in our conversation with the attorney where he said, hey, at first it was hunky-dory. They decided it was covered. They gave me my money. I started working on the case. And then as they saw information about the case, they then changed their minds.
Yeah, and this creates a huge, I think it's easy for people to see the conflict position that the attorney can be put in, right? If the attorney is aware of USCCA's policy, the fact that, hey, if this thing's a criminal act, if they decide it's a criminal act, they drop coverage. So the criminal defense attorney now gets discovery and says to him or herself, oops, this looks like a bad shoot. They might, if I turn this over to the USCCA or their insurance company, they might decide that this thing is a criminal act and this would be a disaster for my client, maybe for me too, since they're paying me. And how an attorney resolves that is beyond me.
We've talked about this so many times, what kind of a problem this causes. And the USCCA has responded to this concern by saying, well, hold on, there's a tripartite relationship between the attorney and the client and the insurance company. Okay, well, that has to do with confidentiality. That has to do with the fact that, okay, if it's sent over to the insurance company, it's not necessarily going to get out there or anything like that. But if the insurance company is the one making the decision, then the choice to send them stuff that could potentially get your client's claim disclaimed by the insurance company goes right up against the ethical duty of a lawyer to only do what's in their client's best interest. This is a horrible position for a lawyer to be in. I'm particularly interested in what I could see myself as if I found myself in that position. What happens to an assigned attorney who refuses to provide the discovery, knowing that it might make that insurance company decide to disclaim my client. That would be me. I would be saying, I'm sorry, I have ethical duties to my client and frankly to the bar. I could get in trouble with the bar if I knowingly do something that could jeopardize my client's position because I'm contractually obligated under this USCCA Delta Defense Agreement.
Yeah, I mean, some people may conclude that that question is unfair in some way. I don't know why they would conclude that. It seems everything asked there is exactly what people want to know, right? So many people have said to us, hey, I canceled USCCA because I found out about this criminal acts exclusion. This is their opportunity to say, here's how it works. And that's why we asked the question. So I don't think that was an unfair question.
Number 2. On page 2 of the USCCA's insurance policy, under Section 1, Part A1E, it states that the insurance company has the right to assign counsel of their choosing, and that counsel must operate with the insurance company's, quote, litigation guidelines, end quote. Here's the subsection. Who decides if the USCCA member's choice of counsel is acceptable? What criteria is used in making that decision? What hourly compensation rates are offered to the assigned attorneys? What are the litigation guidelines assigned counsel is required to follow? And is the assigned counsel required to communicate with the USCCA or its insurance company?
Yeah, I mean, I think, again, USCCA likes to tout, you get to select your own attorney. But that's not what the contract says.
Not what it says.
I mean, that's why it's in here, Section 1, Part A, subsection 1E. That's what it says. So that's why we cited them to exactly the section. So these are legitimate questions. If you want to say, hey, you get to select your attorney, I think it's fair to answer these questions and say, what are the rates? Who gets to decide if it's an acceptable choice? What's the criteria used in deciding?
Yeah, the rates isn't just an irrelevant question.
That's right. Good point.
Good lawyers want higher rates. Our rates are determined by the market. If we do well and you get a good reputation as being a good lawyer, then your price goes up on the marketplace. So if USCCA is not willing to pay what would commonly be known in that jurisdiction as a good lawyer's rate, you're not going to get a good lawyer.
Yeah, what if the answer to that question is the hourly compensation rate offered to the assigned attorney is $200 an hour? Okay, that should tell you right there, you're not going to get an established lawyer who's commanding $500, $600, $700 an hour to work for $200 an hour. You're going to get a brand spanking new lawyer right out of law school. So I don't know. Maybe the answer is $600 an hour, but they didn't answer the question, so we don't know what the rate is.
Yeah. Okay,
so question 3. Here's what it says. On page 2 of the USCCA's insurance policy, under Section 1, Part A1F, it states that the USCCA's insurance company's duty to defend the insured ends upon any conviction for a criminal charge. A, does the USCCA's insurance company interpret this provision to mean that all coverage ends if the USCCA member accepts a plea? B, if so, who represents the USCCA member at any sentencing? C, if so, who represents the USCCA member in any post-conviction matter? D, if so, who represents the USCCA member in any civil lawsuit? E, if so, does the USCCA member lose their insurance liability coverage? F, Tom Grieve released a YouTube video on September 23rd, 2022, stating that the USCCA's insurance coverage ends upon any conviction.
Coverage stops in the event of a conviction.
Is this consistent with the above policy? G, given that Alan Colie was convicted of a criminal offense at trial, how is the USCCA or its insurance company providing coverage for his appellate attorney? H, is Alan Colie's appeal an exception to the general policy of ending coverage in the event of a conviction? I, why does the USCCA's insurance policy include a recoupment clause? On page 8 of the USCCA's insurance policy, detailed in Section I, if the insurance company does not require USCCA members convicted of a criminal act to repay any benefits previously paid. All right, well, look, they put out this video with Tom Grieve saying all coverage ends. And so, to me, these are all questions that me and you and other people interested in how this provision is interpreted, how it applies. I mean, because the vast majority of people in the criminal justice system charged with crimes accept a plea on something.
Around 96% in any given jurisdiction in the United States of America,
right,
people take a plea.
So if all coverage ends, then you can say in 95% of the cases that USCCA decides to extend coverage, all coverage is going to end at the time a person accepts a plea. Okay,
yeah,
so
if they interpreted the contract to mean that, and it seems to mean that. That's a conviction. A change of plea when you plead guilty is a conviction.
Yeah, which may explain why some of the literature that USCCA puts out is so anti-plea, right? We want you to go to trial. Well, that's not USCCA's decision. That's the client's decision after having full consultation with an attorney who knows about the case, right? Who can weigh the pros and cons of going to trial against the pros and cons of a plea. And really, it's a risk assessment, and so the client gets to make that. But if it does end, all these questions are legitimate questions. And then the recoupment clause. USCCA likes to say, well, we don't ask people to pay back the money in the event that this happens. Well, why is it in there then? Why not just take it out? So all these are questions that people have asked, and that's why this was included in our letter. Seems like this would have been a very important question for them to answer.
Yeah, so if you don't speak lawyer and you don't know about criminal procedure, the sentencing question that we asked there, if you do a change of plea, it's usually a separate hearing than a sentencing. Usually they'll set a sentencing 30 to 60 days out in a felony case, depending on your jurisdiction. And there's a whole lot of stuff that needs to be done between the change of plea and that sentencing. You got to prep up to get the best results at the sentencing. Who's going to do that? If the client, if the USCCA member accepts the plea, do they immediately withdraw? Are they just not paid? I don't understand that. And then I think the next few are really relevant too, because they're perks of being a USCCA member that the company proudly holds up and shakes up and says, hey guys, we'll cover you in the case of any appeal. We'll cover you if you get sued after the criminal case. We'll cover you in a civil trial and even pay out your civil judgment. My first question when I saw that was, how do they even get to that if you were convicted? There shouldn't be any way, by the language of this, the way that I read it and the way that it just clearly reads in plain language, nobody is eligible to have their appeals or civil liability covered if they're convicted of any crime, which of course leads into, why is Colie getting it? Is he getting a special exception? If he is, well, I have some speculations on why they might want to make a special exception for that high-profile case. But yeah, I mean, there's so many questions here.
All right. Question 4.
Number 4, we would like to know the USCCA's official position on the following hypothetical question. Quote, if a USCCA member in good standing discharged a firearm claiming self-defense in good faith, but it was immediately determined by USCCA's insurance company and legal counsel that the USCCA member fatally shot a person in the back who was in the process of fleeing from the member after committing a theft, would the USCCA's insurance company extend all benefits, including paying for a criminal defense attorney to represent that member now charged with second-degree murder? If the relevant insurance company makes this determination, how would the insurance company resolve this issue?
Yeah, I mean, this is the question about the bad shoot, right? I mean, somebody who acts in good faith belief that they're trying to act in self-defense. I mean, look, I know people believe that, well, I've got all this great training, I would never be involved in a bad shoot. I've represented people over the last 30 years involved in bad shoots. A lot of them
Countless.
A lot of them had training. It's all fun and games until, as they say, the shit hits the fan.
Right.
And it's in the middle of the night, and maybe you've been drinking, and it's chaos. And, it's one thing when you're at the range, right? And your breathing is controlled, and you got good bone support, and you're pulling the trigger very carefully and not jerking it and all these other things. It's another thing when you're in the heat of battle. And people sometimes, understandably, in a split second, make a bad decision. So that's what this question is trying to get at. What happens when you blew it? We know what happens with AOR. We can answer that question, no problem. We are definitely going to represent you, no problem.
Yeah, the most important line there for our purposes is that they acted in good faith.
Right.
They attempted to act in good faith. That's all we need.
Right. That's what we need. If we can get that, and of course we can get a self-defense jury instruction, which doesn't take very much, we're going to defend that case no problem. So that's really what 4 is calculated to get at. That would have been an easy one. They could have just said, yes, we will defend that person.
Yeah, but I think the answer is no. I think the way that I read their contract is that's a criminal act, and so sorry, no coverage
Well,
for
it
you.
would have been nice for them to answer it rather than for us to speculate.
I think I know why
about
they
it.
don't want to answer it, Mark, but
Yeah.
all right, go ahead with number 5.
5. Does the USCCA or its insurance company extend benefits for a criminal charge where the USCCA member acted in a good faith belief about self-defense, but the USCCA's insurance company and its legal counsel immediately determined the act was not an objectively reasonable, justified act of self-defense? Essentially the same question in a
More general term.
Yeah, more general term. That's what 5's about.
All right, we have a slew of questions next regarding the Alan Colie matter specifically. This is on page 4 of our letter, section 6. Regarding the Alan Colie matter, when did the USCCA initiate its first contact with Mr. Colie after Mr. Colie initially called the USCCA? Did anyone from the USCCA remain in contact with Mr. Colie throughout his prosecution and trial? If so, who? When did the USCCA inform Mr. Colie he was eligible for a paid private criminal defense attorney of his choice, an expert witness, and an investigator? Did the USCCA ever offer Mr. Colie a paid private criminal defense attorney? If so, when and who was offered? If Mr. Colie opted to reject a paid private criminal defense attorney as alleged, did he sign any formal written waiver of benefits? Did Mr. Colie have a paid private criminal defense attorney prior to the appointing of his public defender, approximately a month after his arrest? Had Mr. Colie previously been offered a paid private criminal defense attorney at the time he qualified as indigent to be represented by the public defender? Was Mr. Colie's public defender ever informed by the USCCA or its insurance company that Mr. Colie had free access to a private criminal defense attorney of his choice, an expert witness, and an investigator? If so, when? Other than the appeal, did the USCCA or its insurance company expend any funds on Mr. Colie's behalf for anything? If so, what? Who drafted the email sent to you and signed by Mr. Colie? Did Mr. Colie receive any compensation in exchange for his email to you? Why didn't you mention that Mr. Colie had opted to decline a paid private criminal defense attorney in your video dated December 22nd, 2023? That would have been a good time to mention it.
Yeah, that's pretty telling, right? I mean, people can go back and look at the record here. And Tim Schmidt came out with that video on December 22nd, 2023. If the narrative that they're asking us to believe, which is that we had Mr. Colie's back the whole time, we've been in constant contact with him, he just, having full access to any private paid criminal defense attorney he wants, he opted for his public defender. If that had all occurred, and you're coming out with a video December 22nd, after all of that, trying to defend the actions or lack of actions by your company under the heat of why did this USCCA member have a public defender, seems like that would have been a really good time to come out and say, no. Look, we offered this guy a paid private criminal defense attorney of his choice. He just liked the public defender. But that wasn't anything that was said in that video. So that, to me, is a good question. The other thing here that I thought was interesting was H. Was Mr. Colie's public defender ever informed by the USCCA or its insurance company that Mr. Colie had free access to a private criminal defense attorney of his choice, an expert witness, and an investigator? I think we know the answer to that.
Well, we called him. And we spoke to him in October of 2023. It was shortly after the trial. And he told us he had no idea that his client was eligible for any benefits. He said that he looked up, he saw that he was a USCCA member. Maybe it came to his attention because Mr. Colie told him. And he didn't know what the USCCA was, according to what his lawyer told us. His lawyer told us, yeah, so I looked it up, and I saw that it looked like some sort of a civil liability program. And so I figured, okay, it doesn't apply here.
Right. That's what he told us.
So that strongly implies that at least by October of 2023, USCCA had not reached out to Mr. Colie's public defender to inform him that Colie was eligible for a private attorney.
Yeah, and we've spoken to him at least a couple of times since then, one much more recently. And while I don't want to reveal exactly what he said, I think it's fair to say it was clear to me, and I suspect very clear to you as well, that this guy had absolutely no... I mean, he's applying for funds to the court for an investigator and a use of force expert. And if he had known that USCCA had offered to pay for any private investigator or use of force expert of his choice anywhere in the nation, why would he be asking the court to come up with funds for these things?
The taxpayers of Virginia, actually.
Absolutely ridiculous. I think we can figure out the answer to some of these things. But again, these are questions people were asking. We saw in our YouTube videos these kinds of questions people were asking. This would have been a great opportunity to just simply, if the narrative is as they say, these should be easy questions to answer.
I'll hit number 7 here regarding the Kayla Giles matter. Why did the USCCA or its relevant insurance company decide to stop funding her legal defense? Who made the determination to terminate the funding for her legal defense? Was the attorney who was initially paid $50,000 to represent Miss Giles consulted in the decision to terminate her benefits?
We probably know the answer to that last one.
We spoke to the lawyer once again. We like to get on the phone and talk to people when we can and do some questions. And yeah, he told us that the decision was made basically by the insurance company and that he was required to send discovery in the case to them. And once he sent it to them, and by the way, he hadn't even sent everything yet.
That's
you
right.
mentioned that earlier. Is that, it's one of the things that we had heard from Kayla when we spoke to Kayla, is that not everything had even been revealed in the discovery to the insurance company, but then they just kind of unilaterally, over his objection, saying, hey, this is a great self-defense case, went ahead and terminated.
Maybe the strongest piece of evidence that it was self-defense, right, was the daughter's repeated statements in her interview with the forensic interviewer, right? Somebody qualified and skilled to interview children. On the day of the incident, she had said repeatedly, I want to say maybe 8 times, the victim in that case, which was her now ex-husband, I think it was lunging or jumping at her after he opened the car door. That was never, as best we understand, never even communicated to whoever it was who made that decision to cut off funding for Kayla Giles.
Yeah, absolutely.
These would have been, by the way, very easy questions to answer. These aren't gotcha questions. These aren't tricky questions. These are questions calculated to get at the answer to what happened.
The purpose of doing it in letter form like this was to avoid gotcha questions. They've had months to respond to it. And once again, we hope that they still do. Maybe people will be interested in these and share this with the USCCA. I'm not holding my breath. Number 8. Does the USCCA and its associated insurance company exclude funding for criminal defense services for criminal charges involving firearms that occur in places where firearms are prohibited, such as sensitive areas?
Yeah, this is one that really wasn't clear to me after going through the contract, right? They don't say, like we do very clearly in our fee agreement, that that's not a problem, right? If the self-defense incident occurs in a place where firearms are prohibited, that does not exclude you if you're an AOR member. Does it if you're a USCCA member? I couldn't tell from the contract. Again, it's a really easy one to answer. They could have just said, yeah, that's not a problem for us. Or if it is a problem, tell people. Let them know exactly what it is they're purchasing. I don't know why that should be confusing, why that's a question they refuse to answer.
Number 9, does the USCCA and its associated insurance company exclude funding for criminal defense services for criminal charges involving illegal firearms? Yet another one of the things we very clearly list will not get you excluded from AOR coverage. Why don't they just answer this question? Number 10, does the USCCA and its associated insurance company exclude funding for criminal defense services for criminal charges arising out of domestic relationships, domestic violence?
This is a really big exclusion in my view, and because, of course, domestic violence, domestic relationships is a huge source of criminal activity. People get heated, passions are high, emotions are high. And bad things happen lots of times that arise out of these domestic disputes. And as you've pointed out in many videos, this can be a very broadly defined category, right? Roommates, ex-roommates, people like that can fall inside these definitions. Again, the Attorneys on Retainer program specifically does not exclude these kinds of things. Does USCCA? I couldn't tell from reading their contract, so we figured we'd ask this question. This is the kind of thing, if I was a USCCA member, I'd want to know.
Absolutely, and I would wonder what the rationale could possibly be for that if the answer is yes, they exclude something just because of the relationship between the two people involved, especially as you pointed out how broad it is in many jurisdictions, but no answer on that. Does the USCCA and its associated insurance company exclude funding for criminal defense services for criminal charges where the USCCA member was impaired by either alcohol or any drug?
Yeah, same story here. The AOR program explicitly does not exclude these. Does USCCA? I don't know. Would have been nice to get that answer from them.
Number 12, does the USCCA and its associated insurance company exclude funding for criminal defense services for criminal charges involving firearms where the USCCA member is deemed to have been a prohibited possessor of firearms? Government says you can't have that gun. Do we care about this, Mark?
Not a problem if you're an AOR client. We like to do these cases, so we don't exclude this stuff. Does USCCA exclude this? I don't know.
Maybe. I hope you will receive this letter in the spirit in which it is offered. Many of these questions have been raised to my team, and I want to ensure we are providing accurate information to the market. The Attorneys for Freedom Law Firm is committed to acting only with the highest ethical standards, which includes openness, transparency, accuracy, and scrupulous fairness to our clients, prospective clients, competitors in the marketplace, and everyone else. Our interest is in accurately distributing information to the market about available options. We desire to have a professional and cordial working relationship with the USCCA and all our competitors as we each bring different products and services to a market we all care about. If I do not hear from you by, and this says April 15th, 2024, we're a little past that now, I will assume no response is forthcoming. If you intend to respond but need more time, please let me know when I should expect a response. Sincerely, and it's signed by you.
Yeah, I think this is important because the people who represent AOR, when people call the law firm, right, and they're inquiring about AOR, they ask questions. They say, hey, what about these other programs? What about this? What about that? We don't want them to speculate here.
This is a great point, though.
It's part of the reason we do the videos. It's why we have the comparison chart. I don't want them to speculate. We're not just trying to close a deal. In fact, when somebody signs up an AOR internally, we say we got a win-win agreement. That's what we call. Sometimes I'll go to the AOR and say, how many win-wins did we get today? And we mean that, right? It has to be a win-win or we're not interested in the deal. And in order for this to be a win, the people who sign up in AOR have to understand every aspect. That's the reason why we do a critique of AOR. When you sign up in AOR, you get what I like to call the excruciatingly long, it's over an hour, video of me going through every single word of the AOR fee agreement and explaining the parts in non-legalese that might be a little trickier because we really want people to understand. It's like with us. If you want to cancel, you just call us. Hey, I want to cancel. No problem. No pressure. We don't pressure you on either side about signing up or if you want to cancel, no problem. But we do want to distribute accurate information, not just about our product, but when we compare and contrast with other products. This would have been a really great opportunity to compare and contrast. Like, again, we offered to say, look, if you want to do a live thing, happy to do a live thing. It doesn't have to be with Tim Schmidt. It could be with their representative. Bring their lawyers to the table. Let's talk. Their insurance company. Or if they wanted to be more careful about it, we could have done a recorded thing and they could have maybe edited out parts where they made mistakes. We could have agreed on something to make sure it was all appropriate for, the market when it goes out. We're happy to do that, and we remain happy to do that. If Tim Schmidt calls me tomorrow and says, hey, Mark, I'd like to sit down with you and compare and contrast our different programs, let's do it. We have a certain program. We offer some things. We don't offer other things. There are things, as I've said on many occasions, that USCCA offers that we don't currently offer. We may in the future, so stand by for that. But at the moment, we don't. And we certainly don't have anything near the vast training resources, as I said in the letter, that they have. So there are advantages. And again, we do have many AOR clients who remain members of USCCA. We don't have any animosity toward USCCA. I think what we'd like to do is get as much accurate information. And, to be fair about it, if you really want to know what AOR is about, it goes far beyond the contract, right? You really got to understand what our law firm is about and how we operate, because making money isn't the most important thing for us. Acting with high character is. The people on our team who have been with us a long time, they're here because they like what we stand for. They want to be proud of the law firm they work for. They want to be proud of what they do every day. Acting with honor and character and a commitment to excellence and everything we do is more important to us than making money.
Yeah, absolutely. And okay, there you go, guys. These are the questions that we thought were important. And, as you mentioned, Mark, you and I are the decision makers on all of this stuff, on whenever there's a case that comes in, whenever a client has an emergency and they're calling in, they're talking to us or our associates. At the end of the day, you and I are the ones that make the decisions here. And so because it's more localized to our decision making on whether to represent a client, we get questions from marketing all the time. We're constantly on the phone with our marketing representatives, and they tell us what people are asking. And these are the type of questions that people are asking. And we don't want to misrepresent the facts. We don't want to misrepresent USCCA's position or their own interpretation of their contract. So we do the best that we can to answer these types of questions. But it is really important to people in this community to know the truth about what each of these individual products offer. And so that was the spirit in which this letter was intended. I'm rooting for USCCA in terms of getting back to us. I have not given up hope that you will get that call you were just talking about from Tim Schmidt, and they want to make a video being extremely transparent. Frankly, I'm sick and tired of talking about the USCCA.
Me too.
We get comments on our videos sometimes and say, wow, you guys are just bashing on the USCCA all the time. Actually, no. If you take a look at the latest string of 10 videos or something like that we've released, it's all legal education. It's talking about video analysis and whether this was a good shoot, a bad shoot, what types of laws are implicated in this particular public interest story. Here's the overview of the criminal justice system. That's the type of stuff that we like to make videos about. But these types of videos that we do are popular. And they're popular, I think, in large part because people want to know the answer to the question. And they tend to share these types of videos. And I think people also like a good bit of controversy, so maybe they're more likely to click on it. But we're not the ones who decide which ones of our videos are popular. You guys are the ones who decide which ones of our videos are popular, and based on that popularity, engaging that, we want to make sure that, we're answering questions that are important to you guys as our clients.
So, look, maybe USCCA will change their program in some way in the future, and we'll need to revisit it to compare and contrast so people know what's going on. But if they don't and nothing else comes up, I'd sure love to close the chapter on all of this stuff. I think people who are interested in these issues, the record is clear at this point about what our position is, whatever their position is. Some people might look at this letter and say, I don't know, they were unfair questions or you guys shouldn't have done that. Okay, whatever, no problem. That's what we did. We made our best effort to try to get accurate information on the cases that came up that were controversial, the parts of their program that we've talked about. They're the ones who said there were lies and misinformation. Okay, where? What? Whenever we cite something about the USCCA contract, we cite the pinpoint site, exactly where to look. And we did the same thing here. People are free to take this letter and take a look at the USCCA contract to see if we got anything wrong or misstated anything. I'm sure they'll let us know. And by the way, if we did, we'll correct the record and we'll own it. We'll say, you know what? We made a mistake. No big deal. Sometimes you make mistakes. That's what life is.
And also on that point, if they send us back answers to these questions that we think are good for the market and good for consumers in this particular area, we'll commend them for those.
Yes, absolutely.
They deserve to be praised if they cover some of the things that we're asking about.
When I said in the letter that we could have a civilized conversation, I meant it. I don't want to have a knockdown, throwdown, ugly. In fact, I like Tom Grieve. He and I have struck up a bit of a friendship. I get texts from him every now and then. I send him a text every now and then. I respect him as a lawyer. I know he's pitching for USCCA. That's fine. There are other lawyers who pitch for other programs. Andrew Branca is another guy we respect very much. And so, we're lawyers. We're professionals. No big deal. So I encourage them to respond. If they get this video and they say, you know what, we should have responded, okay, send us the responses. Let's talk about it. No biggie.
All right. Well, thank you very much for tuning in today, guys. And I want you guys to go and check out our very extremely transparent website, attorneysonretainer.us, where you will find a copy of our fee agreement that you can go through line by line, as well as many videos explaining it and answering your questions and FAQs about it. So please go and learn all about our self-defense program, which we believe is the best on the marketplace, because we've listened to you guys and incorporated your suggestions, and it just keeps getting better and better. Also, go and check out attorneysforfreedom.com. Like Marc said, it's not enough for you to know about our program. You got to know about who we are as lawyers, who we are as people, and how we see our job and our role in the criminal justice system for our clients. If you like this video, be sure to like the video, subscribe to the channel, and share it with a friend. Leave us a comment down below. Until next time, my friends, this is attorneys Andy Marcantel and Marc J. Victor. Peace.
Peace.